SJC-11210, Commonwealth versus Collazo.
Ms. Billowitz, good afternoon.
Good morning. May it please the court, Elizabeth Billowitz for defendant appellant Jose Collazo. At trial, Mr. Collazo conceded guilt to the offense of manslaughter and was convicted of first-degree murder. There were 3 errors, however, that affected the degree of guilt. First, in a recorded interview, the police made several accusatory statements and Collazo denied them, constituting inadmissible hearsay that should have been excised from the statement. Collazo denied being in the location of the crime, he denied a motive for the crime, and he denied committing the offense altogether.
And why do you say it's inadmissible hearsay? I know that we have case law, but it seems as if the case law, as it has evolved, says, well, it's not hearsay because it's a statement of the defendant. It's just not relevant if it's a pure denial. But here, it is relevant because it goes to consciousness of guilt that, in fact, he was in Lawrence at the time, and and if he said he did not love her, that would be, if true, that would bear on the issue of his claim of manslaughter.
The case law has consistently said that the rationale for this rule is hearsay. At one point earlier in the jurisprudence, there was an additional rationale having to do with impermissible comment on a defendant's invocation of a constitutional right to remain silent. And then in Womack, several years ago, this court said, no, it's not a constitutional issue. It's a purely evidentiary issue and one of hearsay.
It's not an admission, and if it's not an admission, it's an adequate statement, I guess.
That's precisely correct. And so when the defendant...
Either way, it doesn't come in.
That's correct. And so when you have...
But unless there's a reason for it.
That's right.
Which is really where the rubber meets the road, right?
Well, this court has addressed multiple times the issue of how consciousness of guilt plays in here. And in Diaz said that it's a little bit of a circular argument because if a false denial was admissible as consciousness of guilt, then it would completely swallow.
That's a false denial in and of itself. The question is whether or not there's a false denial there's a denial that has to do with a misstatement of evidence. Like he puts himself somewhere. I went to the grocery store when he wasn't at the grocery store. There's got to be something more to it.
Well, there have been several cases where this court has held that...
The police can't just yell at people and say, you did it, and they say, no, I didn't. That doesn't come in, right?
But
it has to be an unequivocal denial. He's adding stuff. That changes. He's talking. He's not just denying. Once he goes beyond that, it's fair game, right?
There are multiple aspects of this, and let me see if I can take these in order. First of all, this court has made clear that it doesn't, the doctrine isn't just limited to when the entire statement consists of an accusation and a denial. This court expressly disagreed with that argument in Womack and said it applies equally to exchanges made within the context of a larger statement. That's what we have here. The police accusations can be in the form of a question. And specifically, it can be in the form of questions about a defendant's whereabouts, and I think this gets to your question, Justice Gaziano. In Commonwealth versus Diaz, the defendant's denial that he was in the city on the date of the incident, very similar to here, should not have been admitted. Commonwealth versus Emeni and Santana also dealt with questions about the defendant's whereabouts.
But I don't get that. I understand the case law, and I think it has evolved over time. The case law to say when you've got the investigator saying, come on, you did it, I've got this evidence, this evidence, this evidence, this evidence, admit that you killed her, and he said, I didn't kill her, that the Commonwealth is getting all that in purely to get in the allegations, not to get in what he says. But when he says, I wasn't in Lawrence, and there is substantial evidence from his friends, wholly apart from the killing, that no, he was in Lawrence, that becomes important and relevant information. So why should the Commonwealth not be able to get that in?
Because it's not an admission and it does not fall under that exception to the hearsay rule.
Doesn't it have to be in response to an accusation of criminal activity and locate this, in this case, it has nothing to do with whether he did it, it was where he was.
Some of the statements in the exchange were more direct about the offense itself. When the officer says, you don't feel bad at all, he makes a very express denial. For what am I going to feel bad about if something I ain't did? People are accusing me. I don't want to go down for some BS I didn't did. Also, questions about whereabouts, which constitute opportunity, again, are the sort of implied accusations that this court has repeatedly held fall under this rule. So it's not like this, the most recent case that this court decided, Collazo, that it's not comparable to that, where the defendant was just asked if he knew the victim. This is closer actually to Spencer, where there were questions, police asked questions about relationship and about motive that were properly excluded, whether the defendant had a beef with the intended victim.
But, okay, so the statement that I was in New York was not admitted for its truth. It was admitted precisely for the opposite reason, that it was false.
Well,
Why is it even hearsay at all? Because it was not admitted for its truth.
even if this did not fall under the hearsay rule, it certainly would be more prejudicial than probative.
Why is it?
And I also,
Well, I know it hurts, but that doesn't mean it's unfairly, it has to be unfairly prejudicial. So the Commonwealth wanted in the evidence that said, I was in New York, I was not in Lawrence, not to show that he was in New York, but to show that he was lying about where he was, and he was lying for a reason.
well, and this gets back, I think, to the circular nature of consciousness of guilt, which does not provide an exception to that rule. And before I forget, I also wanted to respond.
But for hearsay to be hearsay, it has to be admitted for its truth.
Correct.
And this is not being admitted for its truth.
Well, there certainly wasn't any kind of limiting instruction that would have explained that to the jury. So what the jury was left with was a defendant who was obviously lying. His defense attorney in his closing argument had to say, my client was lying through his teeth. So it showed him, especially without a limiting instruction, it showed him to be scheming, it showed him to be duplicitous. He walked into that police station, he turned himself in.
What would the limiting instruction be, though? I mean, they put it in to show he was lying, and there it was. What would the judge have to say? The jury doesn't have to understand that this is not hearsay. Well,
I would say that this was, for those reasons, just more prejudicial than probative. It wasn't an admission, and just going back to, I think, your question.
Miranda says, anything you say can and will be used against you, right? So he is saying stuff. He's not exercising his right to remain silent, and he's not denying. He's not doing a simple denial. He's lying about things. We got hundreds of cases that say that's okay, especially it's showing, we know he's there and he's saying he's in New York. I mean, that can't be right. I mean, Well,
he is
You got a
denying
case
the
that doesn't-
location, he's denying the
No,
motive.
but that's different from, those cases about denials are absolute denials. I didn't do it, or, they're not cases, I wasn't somewhere, or we had consensual sex in a rape case. Those, that all comes in when, it's different.
Well, I would ask the court to review the cases cited in in the rebrief and in the reply brief because I do think there is more complexity. And I also would say that these were not equivocal responses. He's verbose, but he's not ambiguous. He says, no, I was here. I know they didn't see me. He says, I wasn't there. I didn't love her. So,
Isn't that admissible? I did not love her, where he
it
claims
was
that,
it was a question about motive, and, you know, again, the alternative argument is more prejudicial than probative. And this was a
But why
case
is
where...
it when his defense is, I was so upset to discover my girlfriend in bed with somebody else, why is it not appropriate for the Commonwealth to offer evidence that he later said, I don't love her?
Again, because it was a denial in response to the police accusation that's clearly related to the crime at issue. And the accusations were particularly damaging here because they involved...
Wait, so under your theory, so if you say I didn't do it, and then you concoct, pages and pages of stuff, all of that, as long as you say I didn't do it, nothing else comes in? Is that it? Is that how it works?
I think so, unless they were inconsistent with the denial. I think that's how this has been treated.
So if you say I didn't do it, everything you say cannot be used against you, as long as you say I didn't do the killing or I didn't do the rape.
Well, certainly if you went on to say something inconsistent that was beyond just a flat denial. The essence of what he said was a flat denial. That's all I'm saying should have been excised. Other parts of the statement, no. But the parts of the statement where he is denying being present or committing the crime.
What impact would that have had, though? I mean, taking that out, what does that do? The rest of it still comes in.
Well, this was so damaging because...
Denial was damaging?
I'm sorry?
You're saying just the simple denial was damaging?
Yes, and that's what makes this case different from so many other cases dealing with this doctrine. The other cases, almost all of them, deal with identification defenses. So when the defendant denies it, it's actually consistent with the defense. And in fact, this court has observed it can be a little bit of a boon to the defendant. He gets on the record the fact that he made an unequivocal denial. That's not something he would normally get to do unless he testifies. In this case, he conceded that he was present. He conceded that he did the shooting. So it showed him to be false. It forced his trial counsel to have to deal with the fact that he had lied. So that was the specific damage in this case. This is significant because although the evidence was certainly overwhelming that my client shot the victim, it was not overwhelming as to premeditation. There was considerable circumstantial evidence that the shooting was unplanned. By the way, there was no eyewitness to the actual shooting who testified. Fajardo said she didn't see anything. So really, we have circumstantial evidence here. Collazo waited until daylight to enter the apartment. He went and talked to his landlord, identified himself, said, I'd like to get my clothes. Can I have something to open the door with? He went in without his gun drawn. He spoke calmly to El Bizu, the friend who was staying there. The key evidence supporting premeditation came from the cooperating witness who gave inconsistent accounts of this critical phone exchange where he talks with Collazo right before and right after the shooting. And it's important to note that even if the jury credited the most damaging part of that cooperating witness's testimony, it didn't preclude acting in the heat of passion. This all took place within minutes, that space between the phone calls.
Don't we have to take the evidence in the light most favorable to the Commonwealth?
Yes.
Okay.
Right, and although I'm not arguing that there's insufficient evidence of premeditation, simply that it was not overwhelming, such that the three errors that I'm arguing here could have affected the jury's conclusion here. So even,
Talk about the gun and how,
yes.
it does seem like it was error, and I'll want to hear from the Commonwealth about that, but can you talk about why it was a substantial likelihood of a miscarriage of justice?
Certainly. So there was virtually no probative value. It was clear that this was not the gun used in the offense. It was not relevant to show premeditation or extreme atrocity. And I'd actually like to draw the court's attention.
Was there instruction?
No, no limiting instruction as to the second gun. And I would just like to draw this court's attention to the Valentin case, and I'll file a 16L letter that I should have mentioned in my reply, which really deals very squarely with the evidence of an additional firearm in connection with premeditation or extreme atrocity. It's really directly on point here.
Of course, it was evidence that he did live there,
That's correct.
and there was a home invasion charge for which he was found not guilty.
That's right. But there was also, it was cumulative, there was other evidence that came in earlier that the girlfriend testified that he had left some of his belongings. So it was not the only evidence. He did not need this to show that he was there. And in any event, this is precisely where a limiting instruction would have come in handy. In Imbert, which you recently decided, there the judge twice instructed the jury not to consider possession of the gun as evidence of bad character or propensity, and reminded the jury that the Commonwealth was not contending that that was the murder weapon. Here, there should have been a limiting instruction that even if, the gun could be considered in connection with the home invasion, but not on the murder count.
But your sister will soon say if the jury was so prejudiced against him, they would have found him guilty of the home invasion. But they found him not guilty of that.
True, they seem to accept the argument that he lived there, which is, arguably a somewhat separate issue. But this was highly prejudicial propensity and character evidence that improperly bolstered the case, the Commonwealth's case, on degree of guilt by showing him to be a lawless, violent individual whose criminality predated the shooting.
Now, the Commonwealth also says that this shows his familiarity with weapons, this gun, and that when he says, and also disproves his argument about, or the point that he just lost it and pulled the trigger since the gun required more actions than that. How does that fit in here?
It's actually a little backwards, because wouldn't that argument actually favor Collazo if he's so familiar with these weapons that he can, shoot 3 times very quickly before coming back to his senses? I don't think that helps the Commonwealth. And in any event, this court in Valentin said that when the defendant didn't make an issue of familiarity with weapons, that it's not relevant, and I think there the Commonwealth contended that the weapons evidence allowed the jury to infer the defendant was familiar with weapons, but that was a piling on of inferences. So I don't think that gets anywhere.
So you're saying it was admissible, but only for the limited purpose of showing he lived there, but that even though admissible for that limited purpose, it was a 403 violation because it was an abuse of discretion to allow it in because it's more prejudicial than probative.
That's correct.
But there was no objection, I gather.
There was no objection.
So we'd have to find that it was not only abuse of discretion, but a substantial
likelihood
of miscarriage of justice arising from it.
Exactly right. And I would also point out that the fact that the prosecutor mentioned the second gun in the closing argument was possibly confusing to the jury because he wasn't referring. Again, there was no instruction distinguishing between the two guns at issue. So I think the evidence that he kept a gun in his closet, coupled with this confusing reference in the closing argument and the absence of a limiting instruction, made the jury more likely to view him as a cold-blooded killer.
So Would you say that the ammo would come in? Because the ammo was consistent with the firearm that was used.
Not if there was ballistics evidence that it wasn't actually used in this case. I think for exactly the same reasons.
The fact that he had, I think it was a .45 caliber, right? Or 20, no, the Raven was a .25 caliber.
That's right.
The ammo was a .45 caliber.
That's right.
And the killing was done with a .45 caliber weapon.
That's correct.
So that would not,
So it would not be possible.
that the ammo was of the same type of,
But I think when there's ballistics evidence showing that that particular ammunition was not used
well,
in
of
this.
course, it wasn't, I mean.
In this case, then it's, it's, there's no probative value. May I touch very briefly on the error in closing argument, because I think these all really dovetail in terms of how this affected the degree of guilt. And here the prosecutor contended that Collazo was motivated by a desire to maintain dominance in his peer group rather than shock and distress caused by the infidelity. And he made this point by literally calling him an animal. He repeatedly called him an alpha dog, top dog, leader of the pack. He says, all these people are my people. This wasn't a reaction. This was about him taking care of business, making an example by showing you can't do this to the top dog. So not only is this gratuitous, insulting, unnecessary, but it's not founded on the record. There was no testimony about anyone in this group of friends being fearful of Collazo, feeling dominated by him, threatened by him, any kind of hierarchical gang structure. The only thing the Commonwealth can point to at this point was that Fajardo called him jealous, which doesn't support the Commonwealth's theory of motive any more than the defense's, and certainly doesn't support an inference that he was some kind of gang leader who shot someone to impress them. And briefly, 3 of the 4 Kozak factors tilt in favor of reversible error here, because this did go to the heart of the case.
Okay, thank you.
Thank you.
Ms. Moriarty, before you get warmed up and get into your rhythm, am I correct that the ammo that was found in the 16 Union Street apartment was the same type that was used in the killing? Am I wrong?
Good afternoon, Your Honors. May it please the Court, Marina Moriarty on behalf of the Commonwealth. Chief Justice, that is incorrect. The ammo that was found in the apartment, as well as the gun that was found in the apartment, was different than the caliber of weapon that was determined to have been
But
killed.
I thought the ammo did not match the Raven.
That's correct. It did not match. However, it was not a .38 caliber. The .38 caliber weapon was the murder weapon in this case that was
okay,
found.
so it was a .38 was the murder weapon. They found 45 caliber ammo
Yes,
and a .25 caliber firearm.
correct.
Okay, so I'm wrong. Thank you.
May I-
But just while we're talking about the gun, do you agree that it probably shouldn't have come in?
I agree it had slight probative value, Your Honor. However, I also would argue that its prejudicial effect was comparatively slight. It did seem to benefit the defendant's argument that he was still in legal possession of that apartment and had a right to go into that apartment, as was argued by the defense attorney in response to the home invasion count. And I would just point out that the case was tried also under a felony murder theory, with home invasion being the predicate felony. So this was a very important point. And I think that went to defense counsel's strategic decision not to object to the admission of the gun and the ammo found in the apartment. He did object. It seemed as, according to the record, he conferred with his client and he withdrew the objection. I think any undue prejudice that was suffered by the defendant is absolutely did not rise to a substantial likelihood of a miscarriage of justice. The court can be confident in that because the .25 caliber gun was barely referenced in the prosecutor's closing argument. It was only referenced in relation to it being an item he abandoned when he left the apartment after his fight with his girlfriend on the 13th. And the jury was clearly not swayed by this evidence of a gun because they acquitted the defendant of the armed home invasion charge, and they also acquitted the defendant of the first-degree murder on the basis of extreme atrocity or cruelty. I would analogize this case to Barbosa, cited in my brief. And in Barbosa, the gun was tenuously tied to the defendant. Here we have a gun that's more closely tied to the defendant. Nevertheless, the court in Barbosa found that the improper introduction of the second weapon was not even prejudicial, based on the quantity and quality of properly admitted evidence and the scant attention that was paid to it at the trial. So it urges court, if there's any error found, it's clearly not a substantial likelihood of a miscarriage of justice. Returning to the defendant's recorded interview with the police, I would argue that it's clear case law that only an unequivocal denial in response to an accusation of criminal conduct would be improperly admitted. Here we have an approximately 30-minute long interview, which is really conversational in tone. It's the detectives getting out a lot of background information about the defendant, where he lived, how many siblings he had. He does talk about his friends in New York. The only thing that comes close to an unequivocal denial in response to an accusation of criminal conduct is the trooper's kind of vague statement, "We heard you were in Haverhill on the 20th. And at that point, the defendant states, no, he was in New York, and that he could be seen on video in New York. But this denial that he was in New York and not that he was in Haverhill was not directly tied to the defendant's culpability, just as this court found in its recent case in Cruzado. There, the defendant denied knowing the victim. Here, the defendant denied being in Haverhill. This is no way an unequivocal denial of an accusation of criminal conduct. In Diaz, cited by my sister, I think that's different because there, the defendant made repeated, explicit denials that he did not shoot anybody. He did say he was not in Lowell on the date of the murder, and he said he was not driving a particular car. The culmination of those three things led the court to conclude that those were unequivocal denials. But even in that case, the court concluded that the error was harmless beyond a reasonable doubt. Here, the standard is whether this would have caused a substantial likelihood of a miscarriage of justice, and it simply would not have. First, the fact that the defendant was in Haverhill on February 20th was cumulative of other evidence of testimony by Driver, Monkey, Simba, and Samantha Hooper and Alyssa Witham. The prosecutor only referenced the defendant's statement to the police in passing in 2 sentences over a 36-page closing argument, and it's not one of the specific points of contention that the defendant alleges. He just was suggesting that some things that the defendant said in his statement were true, and some things the defendant said in his statement were not true. Finally, I would characterize the evidence differently. I think there was overwhelming evidence that this was a deliberately planned, premeditated murder, and that the Commonwealth had overwhelming evidence to disprove mitigating circumstances beyond a reasonable doubt. You have direct evidence that the defendant knew that the victim was in the apartment at the time he went in there. The morning of the murder, he called Driver, which phone records corroborate, and he asked Driver what kind of car the victim drove. In response, he said, "I'm going to get that fucker," excuse my language, and this is just before the murder. He also told Witham that he saw the victim's car at the apartment and had been there all night but didn't see anyone coming or going, and that he was aggravated with him. These direct statements by the defendant are furthered by circumstantial evidence that was presented at trial that the defendant stalked the defendant stalked the victim and his former girlfriend by calling his girlfriend multiple times the night of February 20th. He knocked on the doors. He knocked on the windows late at night.
Was there evidence that he knew just that the victim was there, or also that was there any evidence that he knew the girlfriend was there?
That he knew the girlfriend was there?
Yeah. Because the defense was he was surprised to see that the girlfriend was also there and they were together, I thought.
I think the evidence that he knew that the girlfriend was there there would have been no reason for the victim to have been present if the girlfriend wasn't also present, because he'd been previously told the week before that the victim and his ex-girlfriend were seen holding hands walking down the street. So I think that's a reasonable inference based on the evidence. I think the fact there was testimony that the victim always parked his car right next to 16 Union Street. It would have been visible to him as he was outside. He was seen outside 16 Union Street early morning on the 20th after going to the party at the hotel. Further evidence that this defendant was calm, collected, and rational is the fact that he knocked on the landlord's door, concocted a story, and calmly broke into the basement apartment. Additionally, he would have not been surprised that Jenny Albizu was in the apartment, because he had been communicating with his ex-girlfriend through her phone. So I think that explains his lack of surprise at seeing Jenny in the apartment. A point I didn't emphasize enough in my brief, perhaps, is the fact that the manner in which the defendant committed the murder emphasizes the fact that he was in control and that he was deliberate premeditation. First, there was testimony that he would have hit the defendant multiple times in the face. As the medical examiner testified, there was abrasions, cuts, scrapes on the defendant's face, which was consistent with the blood that was found on the murder weapon, which was confirmed to be the victim's blood. With respect to the shooting, he had to first remove the safety. He had to pull back the slide, which ejected a live round onto the beds, which the police then recovered, and then had to depress the trigger 3 times in order to shoot the victim 3 times. And there is evidence from this court in Coleman, 434 Mass at 169, that multiple shots are evidence of deliberate premeditation. So I think that long explanation of the facts of the case would support any conclusion by this court that any particular error that you find does not rise to the level of a substantial likelihood of miscarriage of justice, because the defendant conceded that at trial that he shot the victim, and that evidence disproves any mitigating circumstances. I just want to touch on the alpha male. Again, I don't think top dog, alpha male, they're euphemisms. I think the euphemisms were supported by the record. The evidence was that this defendant basically could get any of his friends to do anything that they wanted on short notice, whether it was painting, moving, driving all the way to New York City twice on short notice. I think that was the thrust.
What was the relevance of that in context?
That this murder was not provoked by an uncontrollable rage based on finding the victim in bed with his girlfriend. It was not heat of passion, that this was deliberate, controlled.
Would this be in the better left unsaid category?
Perhaps, but this evidence that the defendant, in some ways, made this a very personal attack by beating and shooting the victim 3 times as he was in bed. I think the prosecutor was trying to give a flavor for
That had a lot of evidence.
There was.
Yeah, I don't think we needed it.
And again, there was no objection, which I think shows you kind of the character, the nature of the closing argument as it was heard by defense counsel, the judge, and the jury. And finally, I would just ask this court to decline to exercise its extraordinary power pursuant to Section 33E. Contrary to the defendant's claim, as I've stated, this is not a sudden revelation of infidelity. The jury was able to hear the defendant's story, the defendant's claims, through the statements of Sandra Witham and Alyssa Cooper, and clearly chose not to credit the defendant's statements to them, but rather found the Commonwealth's theory of the case more persuasive, in that they found that the Commonwealth did disproved mitigating circumstances beyond a reasonable doubt, and I would ask this court not to act as a second jury in this case and uphold the convictions.
All right, thank you.
Thank you.
All right. Hear ye,